streaming? Live streaming is on.
Can you do anything about the temperature? No. Because the judge said how hot it was. The MR said how hot it was yesterday. Yeah. Very uncomfortable. I mentioned it to Alan. But yeah. In fact, he mentioned it. Right.
So the best thing is really the windows and
they're all open.
So if there's a breeze, that's about the only cooling thing we're going to get in this room. You could mention it to the judges.
Well, I'm just saying.
Moves up here so that she can speak to Mr. McHenry if needed when he's giving his
What, at the end?
Yes.
Is that okay with you, Matt? Yeah.
Can we not leave the door open? Not really, because of the noise.
You can leave the door open, but there could be noise if people walk past. But as you can see, the windows are open. And I think the air conditioning is actually it's not on at all. I can't feel anything. No. But it's nothing I can do about.
I don't know who controls it.
The
whole building?
No, I think some courtrooms is on because they just have fresh air pushing through.
Yeah.
But some courts they don't
have
have
a
a lot.
Talk to about it.
Accommodation.
I'll ask accommodation.
There's only rise. Thanks. Application of the partner in the matter between on the application of Bell and Nutler and the Tavistock and Portman NHS Trust.
Yes, Mr. Hyam.
Please, your yesterday, I began by outlining our overarching position with respect to the people. And in the light of the questions raised in the course of argument, the structure of my submissions this morning will follow the following course. First, I will seek to explain the nature of the unlawfulness of the defendant's policy or practice that was challenged in the judicial review. And in doing so, I will seek to answer the point raised by my Lord the Lord Chief Justice that it would be helpful to look at the degree of specificity under review in Gillick, and the proper principle to be drawn from paragraph 181F of that decision. The second stage of my submission will be argument as to why, on the court's findings, it was appropriate for the court to grant the declaration in the form that it did at paragraph 138. And in the course of doing so, I hope to answer my Lord the Master of the Rolls' question about whether Gillick is about sufficiency of understanding only, or is about facts, and also answer my Lord the Master of the Rolls' question about why the specific factors in paragraph 138 are the right factors rather than any other factors that might be decided upon. The third stage of my submission will address something I've partly addressed so far, which is why the findings made by the court on the facts, in particular those that are subject to appeal under grounds 4 and 5, which you'll recall are use of puberty blockers, experimental, and the correlation between puberty blockers and cross-sex hormones, are findings that are not vitiated by any procedural irregularity in the court's approach to evidence, and are findings for which the court had legitimate and proper grounds on the evidence that was before it. And I should say that that aspect of the submission will be directed at showing that the court's findings are based on an evaluation by the court of the defendant's evidence as a whole against the background evidence which was before the court, and that it did not involve, and a fair reading of the judgment shows it did not involve, a resolution of a conflict between witnesses called by the claimant and the defendant. The fourth stage of the, I should say, I will also say that it was entirely appropriate for the court to do what they said they did, namely to use the materials as understanding background and context. But I probably already said that. The fourth stage is to say why it was appropriate to give the guidance at paragraph 145. And the short answer is there was a real need to do so, and that justified the exercise of discretion that the court made. And the fifth stage will be a short summary response to the grounds of appeal, picking up from points in my skeleton but not reading them out.
Thank you.
So the first issue under that five-stage process is looking at then, or explaining the nature of the unlawfulness of the defendant's practice that was challenged in the judicial review. And the phraseology, I think I note in paragraph 19 of the judgment, as the court understood it, was policy or practice was what was being challenged. And the case is that that is what was being reviewed by the court, the policy or practice of obtaining consent for young children undergoing puberty blocking treatment. We say, and our argument was and is, that the procedures around, or the process around the assessment of a child's capacity to consent were not sufficient properly to ascertain whether the child had full understanding to be illicit competent. That was the case. The process wasn't capable of giving rise to the consequence that legal, valid consent in law could be given. As such, we say in law, the process, policy or practice, I'll use policy or practice as the phrase, is such as would, I'm now adopting words in 181F, which I'll come to look at in a second, permit or encourage unlawfulness. And what I say the principle is to be distilled from 181F Gillick is that if there is a policy or practice which, if followed, would lead to unlawful acts or decisions, or which permits or encourages I say that that is the principle one gets from 181F, and is how that principle is distilled in another case in our bundle of authorities, the Crown on the application of Letts and the Lord Chancellor, a case about the legal aid guidance for obtaining legal aid for inquests, a decision of Mr. Justice Green. And can I briefly, and I hope it will be brief, take you to the relevant propositions that I seek to line. First of all, from Gillick and where we left off at 181F. So for this, we need the first bundle, the core bundle of authorities, tab 5, begins at page 63. I'm afraid I don't have the internal electronic numbering, but 132, I'm told, should correspond to what is page 181 of the judgment itself.
By all means, use the judgment page numbers if that's convenient.
It is present for the moment.
So this is Lord Scarman.
It is Lord Scarman in Gillick itself. It is only if the guidance permits or encourages unlawful conduct in the provision of contraceptive services that it can be set aside as being the exercise of a statutory discretionary power in an unreasonable way, is the phrase as expressed. And what the guidance in question was guidance as to the circumstances in which it was permissible for a doctor to give advice in respect to contraceptive services to children under 16. And that led, therefore, to the question in the House. Now, in addition to that, there is a passage in Lord Templeman's judgment at page 206 of the internal page numbering of the decision. Between, in particular, C and G, where the memorandum is looked at, and Lord Templeman says the defects in the memorandum constitute, in my opinion, a mistake of law on behalf of the DHSS. The memorandum assumes and asserts that the doctor is entitled by himself to decide whether an unmarried girl under the age of 16 shall be provided with contraceptive facilities, and that the doctor is entitled to conceal that decision from the parent. In my opinion, the decision cannot lawfully be made without the consent of the parent in charge of the girl, unless the parent has abandoned or abused parental powers or is not available. If the memorandum is directed by reason of mistake of law, and if in consequence a doctor making a decision in reliance on the views expressed in the memorandum may unlawfully interfere with the rights of the parent to make an act, etc., etc. And then goes on to say at E, it matters not whether the memorandum constitutes an order, or guidance, or advice, or a mere expression of view directed to the medical profession, or directed to doctors who are engaged in the National Health Service. The issue is not whether DHS are exercising statutory discretion in a reasonable way, but whether by mistake of law. In the principle, I say, to be distilled from Gillick as a whole, looking at both of those strategies, is looked at, as I indicated, by Mr. Justice Green in a bundle which is to be found, in an authority which is to be found at tab 1818 of the supplementary bundle, authorities, and commences at 428 of the electronic in the bottom right hand corner.
Sorry, supplementary bundle
Of authorities.
The first of the four bundles.
The second, sorry, sorry, no, you sorry. Of the authorities bundles, it is tab number 18, so it is in volume 2.
And we don't have tabs.
We don't have tabs. But
We still don't have tabs.
So give us the page number again. It was 420 something, I
It's
think.
428.
Thank you.
Thank you. So that's authorities supplementary bundle 2, I think.
Let's.
The supplementary bundle to page 420. Let's. And from the head note, I don't want to take too long, but one can see that it was a claimant, there was a death in a psychiatric hospital, there was an issue about Article 2, and the issue raised was concerning the guidance given in respect of the availability of legal aid. In terms of principle, if I could pick up in the judgment at electronic page 460, internal page numbering 4529, 4529, internal paragraph numbering 114, 114. If guidance is predicated on an error, then this in principle can sound a judicial review. The Gillick and Lord Bridge and Lord Temple made clear that the court had jurisdiction to grant relief to cure errors made of law, made in departmental advice and guidance. They both cautioned strongly against becoming embroiled when the issues were intertwined with moral, social, or political issues. But there was no impediment where the issue was clearly defined as an issue of law. We say, in our case, this is a defined issue of law as to what is required for valid consent for treatment. We then have reproduced a passage which is from Gillick, which I'm not going to read out, but is there for your notice. It's about the reviewability of the decision. There is then the passage from Lord Templeman, which I have just read to you, at paragraph 116, although it includes the entirety down to the bottom of the paragraph, reflecting right at the end of the paragraph, just before 116, Lord Bridge's warning against the involvement of the courts in areas of social and ethical controversy or hypothetical questions. Again, not our case, we say. And then reference to Tabat, a decision of Lord Justice Richards, I'm assuming a court of appeal, where the point is distilled as follows. The relevant law was considered by the judge at 2014, sorry, the report. He said that the authorities recognise 3 bases on which a court can conclude that the government policies are lawful. First, it's well established that policy which, if followed, would lead to unlawful acts or decisions, or which permits or encourages such acts, will itself be unlawful. And that's italicized there. Now that is, we say, the distillation of the principle from Gillick. It is the principle, I should say, he goes on to give other examples of where the court can intervene, and the kinds of case one's looking at in refugee leagues, I'll just say as a footnote, are inherent unfairness of the policy. And the other way, the same point is sometimes put, is unacceptable risk of unlawfulness. But we don't need to trouble with that, because the Gillick principle, as here distilled, we say, is sufficient for our purpose, because our argument is that if the practice or policy applied by the Tavistock, if followed, would lead to unlawful acts, or permit or encourage such acts, then unlawfulness would be shown, and it would be open to the court to intervene.
And permits in this context really means sanctions, doesn't it? If the policy sanctions unlawful activity. And I think what we get that from, I'm trying to remember the name of the case, but it was a case arising in the context of, I think, the approval of a drug, and it was Lord Justice Underhill and Lady Justice Rose. I'm sorry, its name has slipped my mind, but those with search facilities in front of them will find it in a flash, I have no doubt. But I think that's broadly the understanding.
Well, my lord, if that is, and I could, of course, accept,
well, we might need to look at it.
The approach to permit. Again, that applies to the practice or policy in question, because it sanctions or encourages less than that is required, see paragraph 138, for lawful informed consent. Gillick competent consent. Now, just to understand how the case is put and to understand the point by reference to the document we looked at yesterday, the claimant's case was that the practice as a whole failed to ensure, or was insufficient to ensure, proper competence was being given by children to commence on duty. During the course of the litigation, and as noted by the court when it refers specifically to the SOP at paragraph 38 being referred to by the SOP is that Nigel have for the standard operating procedure. At paragraph 38 of the judgment, because it's introduced by Robert Carmichael, we looked at yesterday. That is the document where one finds, or best finds, the internal advice to doctors as to its approach to JID's consent, capacity and competence recording standard operating procedures. Now, that is not a standalone document. There was a mass of material provided by JID to the court behind Polly Carmichael's statement. That included puberty blocking information sheets which were provided. So it's not about looking at, say, the consent form and saying, well, there's not, you're missing a paragraph there, that should be additional, though that might reasonably be included. And that's what the court said. It's about the process of assessing capacity and how the doctors are going to approach it. So the best evidence for that is the SOP itself. And in effect, therefore, it was the declaration made at paragraph 1 of the order in the terms of paragraph 138 of the judgment directly impugns the service specification which was before the court. Because what it is saying in terms is this is what is needed to be fully understood before paragraph 138, before illicit competent consent can be given.
And could you just remind me that the service specification, whose document was that?
Sorry, I'm using the wrong phrase.
I wondered.
The service specification is designed by NHS England.
Yes.
The standard operating procedure is designed by the Tavistock.
Yes. So which you said that the para 138 directly impugns the service specification before the court.
I meant to say the standard operating procedure.
That's all.
Apologise.
No, don't worry. I just needed to make sure that that was right.
I sincerely apologise for that. Now, I'm going to.
So just to be clear, do you say that the declaration does not impugn the service?
Does impugn.
It does,
It
as
does.
well as the standing operating procedure. Sorry, in exchange with my lord.
Sorry, I'm
In
confusing
exchange
everybody.
with my lord, you've just said you meant to say standing operating procedure, not service specification.
Correct.
My question is it then your case that the declaration made does or does not impugn the service specification designed by NHS England?
It doesn't directly impugn it because the service specification itself leaves it to the Tavistock to design the informed consent process. There's an appendix to the service specification which is called Appendix 6. And
Yes, we did look at that briefly, I think, yesterday.
the service specification is to be found, I think, in the first.
I mean, the reason I ask, and of course come to the detail, but the reason I ask is because, as I understood when we looked at the documents yesterday, the standard operating procedure purports to give effect to the service specification.
It does.
Yeah.
It does.
So I don't see for myself how you could say the declaration impugns one without the other.
My Lord, I respectfully agree with that observation, because it is the service specification, and I can see it by reference to appendix.
Appendix 6 is a
There's
page.
a 541.
That's right.
The core bundle.
Just picking up from what my Lord the Marshal of the Rolls said, is it your case that the standard operating procedure faithfully adopts or implements the service specification? Because my Lord, of course, was saying, well, how can you impugn one without the other?
Well,
but I suppose there might be an argument that the service specification is fine, the NHS document is fine, and would be GILIC would facilitate proper GILIC application, but that the SOP failed adequately to
my lady is
carry it forward, in which case you could impugn the SOP without
my lady is correct. The specification is left to the as I understand from the service. I'm using words unhelpful. As I understand the service specification, it leaves the creation of a standard operating procedure to the discretion of the Tavistock.
having set out
the
criteria in considerable detail.
broad details of what's required for
Yeah.
consent, it then leaves it to the Tavistock to create its own standard operating procedure. If that's the correct understanding, then the Lady Lord Justice King's analysis, which is it is conceivable that you could be impugning one but not the other, is entirely correct. If the real or the proper analysis is that because they are necessarily interdependent, then you are impugning both. That's the counter argument. And I position myself that it was sufficient for the standard operating procedure to be considered to be deficient on the judicial review to justify the court intervening by way of the declaration it made. It's not a necessary part of my case that paragraph 138 also impugns the service specification.
And where do we find, forgive me, where do we find in the judgment
I was going to ask.
this analysis?
This analysis is not in the judgment, but it is implicit from the judgment.
Well, do we see any criticism anywhere of the standard operating procedure as a working document?
Yes, but it's implicit because the criticism is in respect of the findings of fact made based on the totality of evidence and really analysing the defendant's evidence and lack of evidence, particularly in respect of that SOP, particularly in respect of cross-sex hormones and the inevitable or inexorable progression, and the no mention of the highly uncertain evidence base in the SOP itself. And of course, how could there be when the appellant even now denies that there is this causation, this conjunction, not causation, is the argument about cross-sex hormones, and denies that the evidence is experimental or uncertain in that sense. So it is a direct, it can be read as an implicit criticism of the SOP.
Okay, well, Mr. Hyam, I don't want to distract you or divert you from your course. But I come back to a question I think I floated yesterday, was that a rather straightforward one. This was a judicial review claim that sought to persuade the court that the defendant in the claim had acted unlawfully. And you've put the argument, if I may say so, as I have understood it from the judgment of the court. It doesn't seem in the judgment that there is any distillation of illegality on the part of the respondent, but there is criticism. And I come back to the point, I appreciate that the declaratory relief can be very flexible. There are circumstances where advisory opinions are given by the courts, but the normal position is you identify the legal failure and then you consider remedy, and if one of the coercive orders isn't appropriate, then you consider declaration. And I find it difficult at the moment to see quite what the divisional court thought was unlawful in what was going on, because it didn't seem to say so.
It doesn't say so in terms, my lord, but as I've sought to indicate, it is proper and possible to infer from their determination that they must have considered that the current practice was insufficient, or, put in the words of in the distillation of the Gillet, such as might permit, bracket, sanction, or encourage unlawfulness. That is a legal basis on which I say it was entirely permissible for them to make a declaration, even if not expressed in those terms in the judgment.
May I put to you this worry that I have about that approach? It seems to me that when you look at the judgment, you do correctly, you have just correctly identified the 2 points on which the practice was said to be inadequate, and that is the inexorable transition to cross-sex hormones on the one hand, and the finding that it was experimental. And once you say that that is what makes it implicit, that there was a criticism of the SOP, you are surely founding on a finding as between two sets of experts.
My lord, I hope I can answer this in the course of my submission, but my submission is squarely that is not the case here. Both in the way the court expresses itself in the judgment and by reference to the evidence that was adduced before it from the defendant, the court was entitled to say, we evaluate the defendant's evidence, you see it clearly, for example, paragraph 40, I think from memory, but I can take you to it, of this part.
Professor Butler's quotation.
Sorry, 43. And then the following interchange is not a transcript, where the court explains, the court asks for statistical material on the number, if any, of young people who had been assessed to be suitable for PEPs, but who were not prescribed them, because the young person was considered not to be Gillet competent. Ms. Morris could not produce any statistics on whether the situation had ever arisen. She suggested in the main she would work with the young person, given further information, discuss the matter further, and in some cases wait until they achieve further maturity. The court gained the strong impression from the evidence and from those submissions that it was extremely unusual for either JIT or the trust to refuse to give PPs on the ground that the young person was not competent. The approach adopted appears to be to continue giving the child more information, to have more discussions until she is considered Gillet competent to discharge. That's not that particular finding, and I can deal with the other findings as well, is not based on a conflict between what claimant's witnesses are saying and what the defendant's witnesses are saying. It's based on the defendant's evidence and the court's proper anxious scrutiny of that evidence. Because what the court was confronted with was the defendant saying, oh, we take great care, we've got wonderful systems, it's all absolutely fine. And the court probing that evidence, both written in terms of witness statement and documentary in terms of evidence. For example, they cite the early intervention study results, which show no evidence of clinical benefit, and they therefore are entitled to evaluate that. In the same way, they're entitled to evaluate the cross-sex hormones issue, and I'll deal with that separately, and the experimental nature and how they deal with experimental, particularly in paragraph 134, is in accord not with what the claimants are saying, although the claimants agree with it, but is what the defendant's own evidence shows.
For my part, I would like, I'm sure you're intending to do this, to show us where in the standard operating procedure, what parts of that document are impugned by the judgment. So, in other words, what is the conclusion to your implication?
May I do that? It is part of the submission I've arranged. It's coming soon, but there may be a... Sorry, I don't need to sound flippant about that. It's just that there's one or two additional points.
Yes, of course. Well, I'm conscious that you're under some time constraint today, so we must let you develop your arguments, Mr. Hire.
I really am coming on to it. It may be that I hope this now deals with it. Why do we say the court was right to make the declaration it did, which is a statement to the effect that the matters in 138, paragraph 138, need to be fully understood as unlawful? We see that we say first of all, the list of matters that a child must understand, retain, and weigh up, which are set out in 138, was produced by the original court, correctly interpreting Gillick and the subsequent case law and applying that law to the information that had been provided about the defendant's use of puberty blockers. And in passing, now I just try and deal with my lord, the Master of the Rolls' question about sufficiency or fact. We base ourselves, and I have referred to it already, can I give you the reference rather than taking you necessarily back to it, but it's that same paragraph 189 C to D of Lord Scarman's speech, which we looked at on more than one occasion, for the answer to sufficiency. Is Gillick only about sufficiency, or is it about the facts as well? And what, well, it's in the core bundle of authorities. I know you haven't got tabs, and I'm afraid I haven't got the electronic number. So it's page 189 of tab. Oh, it is
this is back in Gillick.
Back in Gillick.
Yes.
I'm sorry. I said I wasn't going to.
Well, I think we could almost recite that part of it now.
The simple point, or not simple point, I say that the fair reading of that paragraph shows it's not just about sufficient understanding, it is about factors that need to be understood, and they are moral and family questions, relationship with parent, long-term problems with emotional impact of pregnancy and its termination, risk of sexual intercourse at her age, and risks that might not be diminished. Second point. Any procedure for assessing a child's capacity to consent to treatment of gender dysphoria must be capable of ensuring that the child retains and understands the salient information, and that salient information is a reference back to this Justice Cobb in S, which we don't need to turn up, because the court summarises the point at paragraph 118 of the judgment and underlines in that passage, which explains that salient facts around adoption would be the essential nature and quality of the transaction and not be concerned with reference. And what the court was therefore doing, and why this is my answer to the Master of Rolls' question, well, why this list? This is the court evaluating the totality of the defendant's evidence on its practice or process for obtaining informed consent, and standing back and saying, well, of that, obviously some matters are peripheral, but these are the salient matters that must be understood in order for valid informed consent in law to be given. And that is an entirely appropriate, we say, exercise of judicial decision-making on the facts before it. Being a question for the court, what facts are necessary for consent to be given, not simply a question for doctors to decide what facts are necessary. And that is the shape of the case law now in relation to informed consent, unquestionably from cases such as Montgomery. As I indicated, a mass of evidence was produced by the defendant as to its procedures, and quite a lot of it is referred to in the judgment. And may I just give you some references to the judgment? They're just references where they service specification at 14 and 33, noting the higher prevalence of autistic children seeking treatment, and at 37, in relation to the consequences of treatment being significant and life-changing. The standard operating procedure is referred to but not cited at paragraph 38 of the judgment. The defendant's witnesses, Carmichael and Butler, are dealt with at paragraph 38 and 40 of the judgment. Isla Swarbrick at paragraph 29 of the judgment, Dr. De Vries, paragraph 60 to 62 of the judgment. And just as an aside, it was information, relevant information before the court. De Vries' own publication, could I just turn this up because it's the source of the statistics that find their way to the judgment. And this is in the supplemental bundle, page 720. This is a pause just in case it's not easy to find. It's supplemental bundle, page 720, a document entitled Challenges in Timing Puberty Suppression for Gender Non-Conforming Adolescents.
This was before the court.
It was certainly before the court,
And
yes.
was the companion paper that's referred to, bottom right hand column, just above where it says commentary, is that
Commentary.
sorry, if you look at bottom 720, then just above that we've got in red the word commentary, and above that in bold there's companion paper.
No, I don't think it was.
All right.
But the relevant part of the De Vries paper at 721, left-hand column, final paragraph. So far, researchers of the limited follow-up studies after puberty suppression show that the rate of adolescents that stop the reversible blockers is low, 1.4%, 1.9%, and 3.5%. I think those, from memory, those statistics you find somewhere in the judgment. And so on. And that was before. In addition, before the court, also from briefs, page 677. She's the third author on this, which is a poster for a presentation to the WPATH annual 2-day conference in April 2019. And a fair reading of that document.
I need the page number again.
Sorry, it's my fault. 677 of the supplemental bundle. And why that document is helpful is it epitomises the concerns that are essentially raised in the claim. One can see it in about 10 lines. In international guidelines, PBs are described as extended diagnostic phase, in which the pubertal adolescents are provided time to make a balanced decision. Even though treatment with PB is described as an extended diagnostic phase, many transgender adolescents seem to experience PB as the first necessary medical step of a seemingly indisputable trajectory, with permanent physical changes through gender-affirming hormones and all surgeries at the end. If treatment with PB is seen as the first step to take in gender-affirming treatment, very young children from the age of 10 make a decision with lifelong consequences, which may include reduced opportunities for fertility. Most adolescents then start suppression continue with the partially reversible steps of sex hormones and surgeries. However, concerns have been raised about the risk of regret as gender identity could fluctuate during adolescence. Furthermore, there are worries about the impact of PB on physical, cognitive, and psychosocial development and the development of a consistent gender identity. An important issue in this regard is whether minors at such a young age are capable of making decisions about treatment with such consequences. One of the eligibility criteria for adolescents with PB is that the adolescent should have sufficient mental capacity to give informed consent to this treatment. Children's competence to consent to treatment is a major issue in paediatric ethics, especially when it concerns consent for far-reaching treatments with possible side effects. I mean, it's a source of the defendant's briefs. But in addition to that, the defendant produced evidence from patients who had been treated. J, I think, I'll make it less wrong, S, D, I think, are mentioned in the judgment at paragraphs 84 to 87. And what they say about their experiences. It included, and I can give you the reference for this in the supplemental bundle, but 2 to 3, paragraph 17 of the supplemental bundle, so 2 to 3. That's right. And going on to, I actually mean 2 to 4, so the next page, 2 to 4. Paragraph 17 of this witness's statement, J, saying, I was asked about my sexuality, but I was not sure of my sexuality at that stage of my life, as at 10 or 11. It was not important. I was a child, it did not matter. My gender was uninfluenced by attraction. So, again, feeding into the evidence, the totality of the evidence. The early intervention young person information sheet is cited by the court in paragraph 63 of the judgment. The early intervention study is again reproduced in the judgment, relevant parts thereof, mentioned at 25 and again at 73. And it's a finding from that study that no child, from the interim report at 2015, no child had withdrawn from treatment. That is to be, the reference for that is within the supplemental bundle. I'll just give you the reference for that. It's about 670. It's a single page. supplemental bundle, page 669. This is a more formal publication than that which is referred to in the judgment. The court had a printout of the published website position of the early intervention study at the hearing. This is a different document, but in the left-hand column and in the penultimate paragraph, you see the sentence, no young people withdrew from GRHA treatment in the first 2 years. In addition, there was the evidence on the NHS website, again reproduced in judgment, paragraph 67, about their change of view or change of expression in respect of reversibility. The second aspect of the judgment and how it approached the defendant's evidence is on 3 occasions the court raised legitimate concern about the lack of data and lack of investigation by the defendant despite the opportunity to produce it. So, for example, paragraph 28, sentence beginning, we note with surprise, and that's in relation to producing data on age distribution. At paragraph 33, the court notes the significant demographic change in patients attending the clinic. It had gone from 50-50 to far more girls attending. And again, no explanation put forward, any clinical explanation as to why there had been this significant change over a relatively short time. This is understood against the background of concerns, which they're perfectly entitled to read by way of background evidence, that it might be social media that is having an effect on why it might account for, they haven't an answer to it, but that might be a reason to explain it. But paragraph 34, the court asked for statistics on the number or proportion of young people referred by JITS for PBS, and we just do not know. And the comment at 35, again, we find this lack of data surprising. The other legitimate concern arising out of the defendant's evidence, again, was the lack of evidence base and the degree to which it was experimental, and that's paragraphs 71 to 74 of the judgment, including at 74 legitimate concerns about the numbers actually refused by the Tavistock. Legitimate concerns about persistence, and I'm not finding that it's what did cause persistence, but that it was legitimate for there to be such concerns, that taking puberty blockers might lead to persistence of the gender dysphoria, rather than the natural desistance that might otherwise occur. And there was, again, before the court, good psychiatric evidence, background, but it's an article I think is mentioned by the operating procedure itself. Is the BRIC paper, which gets a mention in the judgment at 712 of the supplemental bundle.
You say this is incorporated or referred to in these kind of...
Yeah, I'll have to double check. That's my recollection. I don't want to assert this. But this document, on its face, is we see it referred to in the NICE review, for example. No one's suggesting that this is not proper published evidence, or that it's produced by partisan individuals.
This is Dr. or Professor de Vries again.
It's a different De Vries.
Oh, is it?
Martin De Vries.
I'm getting them mixed up.
Yeah.
Forgive me. Better make a note of that.
And what it includes is Part 713. In the left-hand column, a helpful summary of short-term adverse effects, including hot flushes and the references for that, the lack of data about long-term adverse effects, the concern about bone mineral density. Just to tell you where I am, I'm on the left-hand column, second paragraph on the page.
Yes.
The concern that puberty suppression with GnRHA might also influence brain development. There's a lack of studies investigating effects of GnRHA on the brain. One examined executive function, etc., and they're referred to. A little further down the page, query about results applying to girls of a particular age. And then on the right-hand column, some of the concerns are raised. 713, I'm about 10 lines down, beginning with a sentence. Some have argued that puberty blocking treatment prevents devastating psychological and physical harms, including suicide, that adolescents should therefore be able to access this treatment even without parental approval. But others have underscored that there is no evidence that puberty suppression prevents suicide, and the risk of suicide, although high, should not be overstated, and so on. And then arguments against GRHA, which are raised, include possible long-term adverse effects on health, psychological, sexual functioning. Some say that adolescents may be unable to make far-reaching decisions at a young age, especially in the presence of COVID, morbid psychiatric conditions, which are common among youth with gender dysphoria. Further, gender identity develops and may change during adolescence. Concerns have been raised that use of GRHA may influence the process and might increase the likelihood of persistence of gender dysphoria. So, if it is unknown, use that prevents resolution of gender dysphoria. Many pubertal children with gender dysphoria no longer experience gender dysphoria in adolescence, and the experience of romantic and sexual attraction thought to play an important role in this process. Some may come to understand themselves as homosexual or bisexual by blocking sexual development might interfere with this process. And finally, the assuming that there is only one outcome once you start, in other words, the first step on a final pathway. Now, those are reported in a balanced way in that report as legitimate concerns held by the academic community.
Well, it underlies the point that this is for all sorts of reasons controversial treatment.
Yes, and the court don't purport to decide. And
that's
as
not,
you've indicated, they don't purport to say, and this court is not being asked to say whether it's a good treatment or a bad treatment, or it's advisable or not advisable. All the court is concerned with is the question of whether consent can be given against that backdrop. Now we say, and I'm coming now to the SOP and the extent to which it does or doesn't. This is the bit that I said I come to soon. Yeah, I'm reminded, in fact, to mention one further point about the Endocrine Society documentation, which was relied upon quite obtusely. I believe that is at 221.
Tab 2, supplementary 1.
Thank you. Supplementary bundle tab 2, page, if I may, 123. Just to correct something that was said by Mr. Morris yesterday, under the heading 2, 2.1, the suggestion is that those who meet the diagnostic criteria for gender dysphoria, fulfill criteria for treatment, or requesting treatment should initially undergo treatment to suppress puberty development is given a 2 rating. And if you want to understand what that means, you have to go to page 124, right-hand column, final paragraph. What 2 means is weak, and 2 and 2 crosses mean low quality. So it's a suggestion, not a strong recommendation. And 2.2, the suggestion is that they begin it at expression after girls and boys first exhibit physical change of puberty. Again, a weak recommendation with low evidential support. It's only if 2.1 and 2.2 are satisfied or indicated, or decision is that treatment is then indicated, that a recommendation is given, and for that again, the evidence is low quality. That's the correction. As I said, I was going to come on to the SOP and try and look at it alongside paragraph 138. To do that, I need to turn up the SOP itself, in particular, page 53053 of the unagreed bundle. And if I can, the passage I'm really focusing on is to be found at page 057, so 57.
I don't understand why this crucial document is in the unagreed bundle.
I was just wondering.
This is really what's being judicially reviewed, isn't it?
The Lords, I'm checking, but given the chronology, I'm pretty confident that this didn't exist at the time the claim was issued, so it was never a challenge needed.
But it had emerged by the time, because it was exhibited to Polly Carmichael's statement as the up-to-date standard operating procedure which we operated by Tavistock. It was shown to the court, and indeed they referred to the standard operating procedure. That's the word.
I mean, is it cited by the court anywhere?
It's not cited, it's referenced, but not cited. It's referenced at paragraph 38 of the judgment.
And do we have a predecessor of it?
I can't answer that question now. There were a lot of documents behind Polly Carmichael.
But it says it was taken 2 years to develop. So was this the first iteration following on from the service document, service specification? Because what I, for my part, find difficult is that we don't see in the judgment, this is the service specification that incorporated the 2 documents, the Enterprise Society and Double Path, that in due course led to preparation of a standard operating procedure.
I understand
which is then open to criticism for the following 5 reasons.
I entirely sympathise with that concern. But if I can try and express the answer to it in defence of the judgment that's been given, the way the case was brought was a challenge to the practice or policy as it existed. We don't think that this was in existence at the time. We did have information, as some of which is there, information about blockers, and that's quoting the judgment, about what was told to children. As part of the judicial review disclosure, the detail of the process that the defendant operated was exhibited to Polly Carmichael's statement and attested to her in witness evidence. That formed the subject matter of submission before the court, along the lines of, look, these documents aren't good enough. They don't talk about the transfer to cross-sex hormones. And part of the claim was that the information handed out to patients, so the document which was all about blockers or the document was not good enough because it didn't flag up concern. But what the court was concerned with was not, and as expressed in its judgment, was not, is this, and makes clear in its judgment, it's not about how much information you bombard people with, it's about whether the child can have a full understanding of essential nature of the transaction or the salient facts about the treatment. And for that, it's the full range of information which the defendant had produced by that stage, including the standard operating procedure, which is referenced, I accept, not reproduced, which led to the court's concern about, as I've said, permitting or encouraging unlawfulness. Of course, I accept they don't express it in that way, and the answer to these where do you find the judgment is it's not in it. But it is this was, how do I put it, this was a highly experienced divisional court sitting with 3 judges, highly experienced in judicial review, who understood the evidence before them, knew about the ability of the court to make declaratory relief in circumstances where the case called for it. There was sufficient concern before them. And on the evidence that they had read, assessed that in at least 2 important respects, going on to process hormones and the experimental nature of the treatment, the manner in which consent was being obtained, I say in legal terms, encouraged or sanctioned unlawfulness. And therefore, it was appropriate to grant the declaration. I mean, that's
yeah. And I think we've not looked, I think, at the claim form, which it's often not a bad place to start when looking at what a judicial review was about. And of course, the high-level argument you advanced on behalf of the claimants was that no child could ever give consent to this procedure. And the second level argument, if I remember from reading it, was that the information was inadequate. And on both of those points, the court actually held against you. And then you had if I again remember accurately, but tell me, Mr. Hyam, if I don't, you had a fallback position, if I can call it that, which was, well, if consent can be given, or if this treatment is permissible in law, then it has to be sanctioned by a court.
Yes, I think we said that because the circumstances wasn't in accordance with law and wasn't sufficiently clear.
Yes.
And there was a human rights obligation on the court to ensure that the treatment was in accordance with law. Now,
and again, the court didn't go with you on that either.
Well, yes, but if I can explain that in this way, the high point of the case was, as the claim was drafted, that Gillick plus Montgomery read together in a proper way led to the conclusion that information necessary to make a decision needed to be understood and conveyed to the individual. The court said, no, we don't want to go down the Montgomery route. We don't think that's the way of approaching it. But we do think, as they said, that when you're giving a treatment such as this, there are certain minimum requirements before informed consent in law can be given. And the reason we're giving you the declaration that you, in different terms, or giving the declaration in the terms of paragraph 38, because that is the court's analysis of the presenting facts and the concerns which are raised by those facts. And in those circumstances, it's an appropriate declaration. I was going to try and deal with the SOP. Can I try and make this point quite short? The SOP reference that I refer to is just page 57, I hope, of the unagreed version. And what we say is if one looks at bullet point 2 and the bullet points thereunder, while the SOP does address some of the salient information in paragraph 138, it does not address all of it, and therefore cannot be, we say, capable of ensuring that a child understands, retains, and weighs up all the salient matters that have been identified by the court. And for that reason, as I've said, that would permit or encourage the unlawfulness and is a defect of law amenable to JR. And the salient factors.
This is guidance for clinicians we're looking at
It is.
in Appendix B.
It is advice to clinicians, and I would refer back to that passage of Lord Templeton that that's within the range of things that can amount to policy.
Do you submit that it, as a matter of law, was necessary to produce a document of this nature, or would it have been? Was it lawful for the other documents that we've been looking at? So the central NHS document with WPATH and so on, and for doctors to be instructed, clinicians to be instructed, both at Tavistock and then at the other hospitals, you must ensure that there is valid consent.
I think the high point of our is, yes, I do say that it was incumbent upon the service provider to produce a policy or practice or advice to clinicians about how properly informed consent would be obtained for this treatment, because not to have such a policy would give rise to uncertainty and risk of unlawful decision making.
Yes. And is that because of the special nature, if I can call it that, of this treatment? Or because I'm just thinking how that reads over into the thousands of different treatments that there are in the NHS, and it would be quite.
It is special nature.
Yes.
And you see that writ large in that clearly was a potent factor in the court's mind in deciding to do what it did. This special, almost unique, there's a phraseology in paragraph 134 to 138 of why it was so special, the treatment, that it required some special measure. So special circumstances required a special measure, and that's what I say about this treatment. It is no part of my case that in every case, cough, cold, COVID, whatever that it is as a matter of law, the NHS provider can come to produce a policy. But in circumstances where there is, without such a policy, a risk of uncertainty and a risk of unlawful treatment being given because of lack of consent, then I would say that in those circumstances, these special features come out of that.
Could you just tell me, when we're looking at 138 of the judgment, and we're looking at the totality of Appendix A, obviously the wording in Appendix A is very different in its various categories from that in 138. Could you just tell me, by reference to 138, which of the 8 factors you say are not covered or not covered adequately?
I apologise, I was going to do that, I can do it now.
No, sorry, I don't want to take you out of your course.
That is exactly, it's the right question I must answer. It's, first of all, immediate salient factors in 138 are immediate consequences of treatment in physical and psychological terms. That's about puberty blockers. The answer is yes, covered. 2, the fact that the vast majority of patients taking puberty blockers go on to cross-sex hormones and therefore are on a pathway to greater interventions, absent because the defendant doesn't accept it and doesn't accept it before this court. 3, the relationship between taking cross-sex hormones and subsequent surgery, present. 4, the fact that cross-sex hormones may lead to loss of fertility, present. The current discussion of fertility. 5, the impact of cross-sex hormones on sexual function, partial, is my comment about that. 6, the impact that taking this step may have on future and lifelong relationships, absent or, we say, insufficient. 7, the fact that the evidence base for treatment is as yet highly uncertain, absent because disputed.
Well, is it that Portman 56 and on to 57 demonstrated sufficient understanding of what the blocker will do, how it works, possible side effects, as well as an appreciation of the potential for unknown impacts of blockers and the impacts over a longer time frame. Doesn't that do 7?
It doesn't include the fact that the evidence base for the treatment is as yet highly uncertain.
Unknown impact? Very well. Anyway, you say no.
So that's.
Was there an 8th?
Is there an
Yes.
There is an 8th.
That's the uncertain.
That's right, yes. I think we may have elided.
7 was unknown physical consequences, and 8, the treatment is highly uncertain.
I mean, I notice, Mr. Hyam, you say absent in most of them because disputed, which comes back to the evidence question. I know you've drawn our attention to evidence which goes some way to your side of the 2 disputed questions. But if you're saying these are absent because the defendant disputes their factual accuracy, then you are also saying that the court has determined factually disputed questions.
Well, I am saying the court has done that. I'm saying that not in an impermissible way. I mean, the dispute about cross-sex hormones and whether it follows on from puberty blockers is one that was open to the court in a judicial review process.
Well, follows on is one of those rather elastic terms, and what the appellants are saying is that there is a separate and distinct consent stage that has to be followed then, which clearly that does, and that therefore at this earlier stage it's simply not a potent factor.
Well, the court.
And that's
the court
roughly what they're
the
saying.
Court analysed that. Sorry.
Yeah.
The court analysed that, and their conclusion was that cross-sex hormones should be considered to be what the phraseology has been used in the vast majority, in some cases, almost an extra. I'll turn to the passage in the judgment which deals with it. But that is a finding, I say, was open to the court on the defendant's own evidence. It's not simply a question of saying, well, because Professor Gary Butler says, in his opinion, he thinks that you can treat it separately. It doesn't mean the court has to accept that. If the Secretary of State writes a witness statement saying that I took into account all relevant matters, and then on examination, the court says, well, actually, we've looked at the documents, it doesn't really stack up. The court's entitled to say that's not right.
Well, there isn't really a dispute as to the fact that you can use all sorts of language, but Dr. Butler said more than 80%. Some of the De Vries material suggests looking much more broadly than just the institutions we're concerned with, that it's in the high 90%, I suppose, if you extrapolate it. So there's no doubt that there is a strong correlation between those who are accepted for this sort of treatment and then are provided it by the interveners, that they, as a matter of fact, overwhelmingly do go on to have that treatment. I mean, that's one of the few bits of evidence, perhaps, that isn't controversial, but it's the legal effect of it that might.
I ask rhetorically, isn't it open to the court to assess that overwhelming evidence, or the evidence that in the overwhelming number of cases it is continued, and say, as a matter of law, well, I think that's a matter, a fact, that is necessary for the child to understand, for informed.
But surely the question is not the figures, the statistics, the progression as such. It's the consequences if you do go on. And I note that when you went through the 7 factors, you said that the factors that relate to the consequences if you go on, namely potential loss of fertility, sexual function, lifelong relationships, all in one measure or another, are there. So the standard operating procedure that you criticise actually does deal with the substance of what the consequences will be. It doesn't deal with the statistics, but it's hard to see that by itself can be problematic. And you may say differently. Please do.
Well, I do say differently, because I say that sorry to repeat myself, but I do say that what the court is entitled to do on the array of evidence presented by the defendant is to say, well, what are the statement facts that a person would need to understand to give informed consent history? And they include these matters under 38, and nothing less than that is sufficient for informed consent.
When we read through the Endocrine Society path, service specification, and this document, they all refer throughout to the importance of the young person or child understanding the potential fertility consequences. So does it ultimately really matter whether or not that is as a virtue of a recognition that the reality is that those children that start on PBs go on to the next stage, the fertility implications, if they're saying, but we have a separate consent process, because it would appear by their emphasis on the importance of children understanding about fertility, that even if it is a separate consent process, that they're accepting that even at that very early stage, the children have to be advised about fertility, and they are.
Well,
Now, I don't know whether you think it's adequately done or not, but it's just that when it's a key point of your argument about the SOP, that they're not accepting your position on
Well, it is. I don't want to repeat myself, because I can just tell you what my case is on this. It is that the SOP is deficient in the manner I've described, because it doesn't reflect paragraph 38 sufficiently. There are accepted references to some consequences, and it appears to be accepted, as you have rightly indicated, whether by Endocrine Society or anyone else, that it is at stage one, that the child has to understand the bigger picture. What's coming down the line if I start cross-sex hormones? It may result in me persisting. It may result in, as the informed consent form, I think, says, it may influence your perceived gender identity and how likely you are to change your mind about your gender. It may mean a lifetime of drug treatment. It may mean that in respect of sexual function, you're not able to achieve sexual function either adequately, or if you are, then it will be only after considerable surgical intervention and so on, all of which are dealt with in statements. Now, the focus of the court was clearly, and was very concerned when it got answers such as repeated at paragraph 44. We got the strong impression that no one's ever actually been refused. We just, the information is reiterated.
Mr. Hine, of course that's right. Of course the court was concerned about that. But the problem that I see is that seems to be very much a balancing of evidence, because who knows what the reasons are. It could be, as the respondents say, that this is a very carefully selected cohort and they suffer from particular signs that mean they will go on. But it could be the reasons you give, that there are other external factors which are very concerning. But all that is a matter very difficult for the court to assess on the judicial review.
Well, can I answer that by saying, yes and no. Yes, if the role of the court is to assess the efficacy of treatment, but that's not what the court was doing. The court was using that evidence to understand a much more simple question, a prime question, which is, what does a child need to understand to be able to consent to this highly complex, significant, and life-long change, almost unique, experimental in the manner used in paragraph 134, treatment. And that was the sole focus of their attention. They repeatedly say that. We're not here to decide clinical disputes. We're not here to. It's entirely appropriate for the NHS and regulatory bodies to decide what treatment's appropriate, what service specification should say. But what they are saying is that we're focusing on consent in law, and these are the key prerequisites to that consent. And so I do say that that is not something that the court should shy away from. And it was entirely appropriate exercise of judicial decision making on the evidence before them to express themselves in the manner they did at 138. My Lord and Malay, may I, with one eye on time, sort of move on? There are two, I'm at what is called now stage 4
Yes.
of my process.
So this is moving to the
This
guidance.
Now, what is, why was it appropriate to give guidance? Was there a real need for it on the basis of the findings made by the court? Now, again, this stage, I don't want to overburden you with references. I'm trying to use the judgment where I can. But what I focus on first of all are nature and purpose of treatment. And to begin that is the judgment itself, paragraph 134. The starting point is to consider the nature of the treatment proposed. The nature at 134 and purpose at 135. And a summary of those matters. First, real uncertainty over short and long-term consequences with very limited evidence to its efficacy. Pausing there. That's not a resolution of conflict of evidence. That is an entirely appropriate finding on the defendant's own evidence. I've referred you already to the Endocrine Society guideline and the weak recommendation, paragraph 2.1. I've also already referred to you yesterday to the Carl Hennigan paper summarising the limited research evidence, the editor of the BMJ and Professor at Oxford. The reference for that is supplementary bundle 671 to 2 and 674. And of course that is then corroborated, or be it after the events, by the nice clinical review that has subsequently taken place. And may I just turn that up just for one moment, really only. That's in the unagreed bundle at 98 to 99. We have critical outcomes on page 98, the decision making, are the impact on gender dysphoria, mental health, and quality of life. The evidence of these outcomes was assessed at very low certainty using modified grade, and indeed in a tabulated form towards the end of that nice document at 195 and onwards in a landscape where you can see how the evidence has been graded pretty much very low across the board for, and I can just summarise this because I don't think we should take too long on this, effect on gender dysphoria, certainty of evidence very low, effect on depression very low, effect on anger very low, effect on anxiety very low, effect on quality of life obtained, the reference to that is 115 for the narrative. Impact on body image, very low. Impact on verbal functioning, very low. Psychological functioning, very low. References. So, in terms of low evidence base, there could really be no argument about that. That was a finding open to the court on the evidence we had. It then says, or indeed, this is judgment, or indeed, quite what it is seeking to achieve. And that picks up, we submit, on some submissions that we made below in our skeleton. And can I just give you the reference for that? That's at core bundle 553. And the difficulty with understanding precisely what it is for, whether it's to alleviate distress or so on. Now that's the claimant's submission, but to show that this isn't a disputed issue, it's a fact that in the appellant, there are two documents that show that this is something that could be determined by the court on the defendant's own evidence. The HRA report is the first document you see picked up in the judgment and reproduced. I hope I'm not going to take you to that because the relevant part is reproduced in the judgment. I think you're alive to that point. If you'd like me to take you to it, the reference is supplementary bundle 697 is where you find the HRA point about it would have been more helpful if you had described it as entry. The appellant's own pre-action letter of response in the unagreed bundle at page 81 to 82. Sorry to be moving around these statements. Paragraph 32 of page 81 puts 5 different purposes or potential purposes for, or such reason, inclusive reasons for treatment, including at 32.5, suppression of puberty can allow subsequent cross-sex hormone treatment for an appropriate age, etc., etc. Although we think that within the course of this litigation, it's not being accepted, certainly not fully accepted, but that is a purpose of treatment. I've already taken you to the BRIC references about uncertainty. The next aspect of the finding is the consequences of puberty blockers are highly complex. I'm not sure if one needs evidence on that. It's obvious that they're highly complex. There's plenty of evidence the defendant has about that. Whether it be Hennigan, BRIC, we put in some evidence about that from Evans as to the brain. But again, even if we didn't put evidence, this is a response to the criticism that they refer to one of our witnesses, the divisional court refers to one of our witnesses, Professor Scott, is that in the appendix 6 to the service specification, which I took you to before, which is in core bundle 1. There isn't any one core bundle, which is in the core bundle.
Starts 484.
484, and the reference is at 541. One can see that the footnote to the service specification on informed consent references the publication by Hine, I.M. and others. And that document, which we have reproduced in our bundle at supplemental bundle page 650, so supplemental bundle 650. At the bottom of the page, explains that differences in decision making between adolescents and adults have been found in the ability to think responsibly, the ability to restrain impulsiveness, and the ability to place a given decision in larger temporal context. Data suggests the adolescent brain still differs significantly from the adult brain, not least because the frontal lobes are essential for effective executive mature later in children than they do in adults. Adolescents generally do not fully possess the capacity to appreciate the long-term consequences of their choices until the age of 21. So even, we've seen it from the degrees as well, the concern about young people making these young choices. So again, a decision of the court, or conclusion of the court, that this was a highly complex decision that might be difficult for children to understand, in no way rests on the court resolving a conflict of evidence. And as to the leading on to, almost inevitably leading on to cross-sex hormones, we've already to a certain extent covered that. And we've looked at the statistics, and we've looked at the endocrine society. So coming back then to the first issue at 134, which was the nature of the treatment, undoubtedly complex, and as to the purpose of the treatment, 135, it was highly uncertain. See submissions in the skeleton, as I've just alluded to. Against that background, the decision to give guidance, we say, was entirely appropriate, because here there is a cohort of children who may be being exposed to treatment. And against the background of their finding, the court's finding, paragraph 44, that pretty much no child that the Tavistock was able to identify had not been prescribed because not considered to be given competence. The court was entitled to consider, well, that's all a bit concerning. So are you saying, I say probably, or say that they're saying, are you saying to us that in the 10 years that you've been giving this treatment, and you haven't kept data, as far as we can tell, you haven't produced the data to us, apart from recently, that not a single child has been found not to be given competence under your practice, even though the target age of treatment is TAMA stage 2, and even though on your statistics, Alsa Swarbrick has produced at least 3 10-year-olds, or at least 3 10-year-olds in that time period, then in 12 11-year-olds or 13 12-year-olds. Is it really the case that on one occasion you found the child not like that? Was clearly in the forefront of the court's mind. And we're now looking at the question of should the court, as a matter of discretion, give guidance essentially to the Tavistock, but of wider import. Because although the JIDS operates under a service specification and does so and refers children for puberty blockers to UCL and leads for that purpose, puberty blockers are available elsewhere. And the purpose of the guidance is to bring home to those medical professionals, whether at the Tavistock or elsewhere, the real concern that the court had as to the likelihood of children as young as 10, 11, 12, 13, 14, 15, 16, in different and stratified way, being able to comprehend that which needed to be comprehended in order to undergo treatment. And the point put pithily at point 6, adopted from when they distill 6 principles that they feel are applicable, and they adopt a submission of Mr. Skinner, who sits to my right, at 132, that in deciding what facts are salient and what level of understanding is sufficient, it's necessary to have regard to matters which are those which objectively ought to be given weight in the future, although the child might be unconcerned about them now. A highly relevant point in light of the evidence of the children who talked about being unconcerned about puberty blockers at the time they commenced them. Sorry, unconcerned about their sexual relationships, because it wasn't on their radar, it wasn't something that featured to them. And that's why we find the sentence, on the facts of this case, there are some obvious examples, including the impact on fertility and sexual functioning. And in that context, therefore, we say, as a matter of discretion, it was appropriate to give the guidance that they gave. Guidance which does not purport to say never, but rather suggests that there is, the phrase we used in the skeleton was a rebuttable presumption. It's unlikely, or very unlikely, that a child of 13 or 12 would be able to consent to something which, on the evidence, is very unlikely that they could have any proper conception of. That's really
now, a rebuttable presumption is a very legal construct, and it doesn't. We don't find that in the judgment anywhere.
No.
When we're looking at the guidance to which you're referring at the moment, i.e., the paragraph 144, 145 and following guidance, no order was made in respect of those observations. So what legal significance do they have?
They are. Can I put this right? I think they. The way I'd like to answer this is the way that I think Lord Justice Lewis, in his book Judicial Remedies, Public Law, Judicial Remedies in Public Law is the title of it.
Yes.
Would put it, and in a moment I'll find the exact reference, but is that you would give guidance if on the facts before you there appeared to be a real need in the special circumstances of the case. Now it's not a matter of law, a failure to follow the guidance, it is just guidance. And I think a case referred to by the learned friend, the local authority in B, paragraph 62, includes the comment. Well, as long as it's treated just as guidance, there's nothing wrong in principle with such guidance. But and we would say there's nothing wrong in principle with this guidance. We don't accept that it sows confusion. To the contrary, we think it's pretty clear. And we think it is beneficial to doctors, patients, parents.
Can I just ask you a practical question? You mentioned a moment ago about that obviously GPs can and often do prescribe the puberty blockers. So is the procedure that the assessment takes place at the Tavistock? They then make a recommendation. Now, do all children then go on to either to one of the 2 trust hospitals, or do some of them simply go to their GP, touching their recommendation from the Tavistock? I presume that they go through everyone goes through the funnel of going to one of the 2.
Well, can I try and answer that by
Ms. Morris is nodding.
Yes. is one answer. And that in the evidence that's before the court, there's the child, the 13-year-old child, remember, and it's a point made by the appellant actually, that on the waiting list, so went privately. So there are other routes to getting puberty blockers, which is you go for a private gender consultation, and a prescription is made by the private gender clinic, which is then maybe issued or repeated by a GP.
I see.
In practice. That's my understanding, and I think that's one of the concerns of raising.
I apologise for interrupting, but I think it's pretty important that we're all clear about how these things happen. We are only concerned here, firstly, with NHS treatment.
Of course.
This case is only concerned.
No, understood.
And then, first thing. Second thing is, the way that it works is, as I explained yesterday, what the Tavistock clinic does is make a referral. That referral will be either to the London Hospital or Leeds Hospital, depending on geography. Those hospitals will then apply their own processes. There'll be their own deliberations and considerations with the patient on that. And they will then make a decision about whether or not to prescribe. Thereafter, there are cases where it is the GP who then continues.
I just wanted to confirm what I believe to be the case was that it can't be Tavistock straight to a GP. It always goes through either Leeds or London. That was all. That was the answer.
That's absolutely it.
I'm sorry, Mr. Hyam. I was going to ask you a question about what you said before my lady's question. It's this really. How can the guidance that the court effectively normally needs to give approval be consistent with the Gillick authority, which makes clear that these decisions are for doctors, not the court?
There's a short and long answer to that. Can I give the answer which is most succinct? In Gillick, you see from Lord Scarman's speech that the decision to leave it to the doctors was a pragmatic decision based on keeping up with social developments. And what Gillick therefore tells us is that in practical terms, for these decisions, one should leave it to the doctors with the addition that certain factors, say the salient facts in Gillick relating to contraceptive advice, effects on future pregnancy and so on, need to be understood. In relation to the guidance, what Gillick says is that there is no fixed limit, but it also says, and there is a reproduction of part of Lord Brandon's speech in an earlier case, which talks about there are some ages where it sort of necessarily follows that the child can't consent, for example, a 7-year-old. And this is what I suggest the court was doing when it approached this case. There are some ages at which one can say it necessarily follows. Then there are other ages where there's a sort of intermediate stage where they may and they may not, depending on the treatment. And an example given by, in the passage cited from Lord Brandon,
About 14-year-old.
It's at 188H. It's an example from Lord Brandon's speech in The Crown Against D. And in the context they were talking there about the kidnapping of a child, and says between F and H, In the case of a very young child, it would not have the understanding or intelligence to give its consent. So that absence of consent would be a necessary inference from its age. So that's category 1, where age is capable. One can make a necessary inference. In the case of older child, however, it must, I think, be a question of fact for a jury whether the child concerned has sufficient understanding in terms to give its consent. If but only if the jury considers the child has these qualities, then it must go on to consider whether it's been proved by the child did not give consent. While the matter will always be for the jury alone to decide, I should not expect a jury to find at all frequently that a child under 14 has sufficient understanding and intelligence to give its consent. Now, all the court is doing is that. And that is not consistent with Gillick, but we say compatible and consistent with. I've in fact now completed stage 4, so I'm now on the stage 5, which.
Well, just before we leave stage 4, the Divisional Court has suggested that in respect of all children 16 and under, there must be an application to the court, and it's advisable also for older children in the event that the clinicians doubt that the consent is valid. Yes, forgive me, 16 and 17s. So again, following up my lady's question about the practicalities of this, who applies, given we have child, parents and clinicians all in agreement, and when is the application made? I mean, this is a challenge to the Tavistock clinic at this judicial review, who don't actually prescribe these drugs. They're a gateway, aren't they?
They are a gateway, Noel, but they are the crucial gateway because they themselves have to assess whether the child can give informed consent before referring. So
yes, but there wouldn't be much point in going to the court at that stage, because the answer would be, well, whatever the Tavistock think, either Leeds or London have got independently to make their own judgment about consent, and we have information about their processes. So it just struck me as being premature, even if in principle it was right. So we then move to the next stage, which involves the two other trusts, and so is it either the hospital, or is it the child, or is it the parents who are supposed to launch these proceedings?
Well, the answer is the hospital. But before just giving that flat answer, can I just explain another point, which is that a distinction has been sought to be drawn throughout these proceedings by the defendant between it and the UCL and Leeds.
Yes.
They are in fact part of the same service that is provided, and we've made that point in our responses to the claim throughout. And so that's the first point. So we treat GIDS, the GIDS service, and indeed if you want to complain about the GIDS service, whether it be Leeds or you in fact write to the GIDS service at the the application would be made by the doctors in the way that applications are made in best interest cases when it's considered that treatment is appropriate. Now, when this was canvassed below, the court did not see either, was not frightened by the practical consequences, because thought that in fact it wouldn't be impractical at all. These are applications that are considered by the court on a regular basis, where there is treatment required for a child who is not able to consent. The consequence, the difference that has happened subsequent to this decision is, of course, the decision in A and B, and others in front of Justice Lieven. And the consequence of that decision, which, as it stands, is a binding High Court decision.
Well, it's not binding on us.
No, sorry.
Yeah, but I'm a little. I have to say, I'm a little puzzled about whether you, in your skeleton argument, you accept parts of that decision and criticise other parts. But again, if it's accepted that the parents can consent without the need to go to a court, if that is accepted, then where on the evidence that this case is concerned with, namely that the parents, the only basis upon which the treatment will be given will be that the parents have consented.
Well,
Where does it leave it?
well, can I try and respond to that as best I can? As you know, when we brought the claim against the Tavistock, the response as to whether parental consent would be valid in accordance with the service specification was no, we don't conceive of any circumstance in which we would accept parental consent. After the decision was held, an application was made to the court that parental consent could be appropriate. And that is, as we point out, I'm not, at this stage, I'm not trying to argue that that application was improperly made or anything like that, but it is different from the service specification, it is different, and the eligibility criteria, it is different from the WPAT eligibility criteria, which I showed you. So, the landscape has changed in that, in the circumstances where all are in agreement and there's no real doubt, there won't be an application to the court if parent, child and clinician are in agreement, subject to, as just been identified, the establishment of a panel which can effectively give it a second, a bit like a second opinion appointed doctor in a mental health case, can review the propriety of the recommendation. I don't, at the moment, I'm keen not to say whether I accept the fact of that decision, but I don't accept its correctness, because there was an argument clearly to be had and identified by Mr. Justice Lieven that actually this kind of treatment does fall into special category. But that argument hasn't been found. But the practical consequence of the guidance, in the light of it, in terms of the court will come to a standstill because there'll be so many applications, is clearly not real, because it's not going to be, in the cases used by the JID service, not going to be necessary, because there's a filter process, including this external panel, who will review the application.
It goes further than that, doesn't it? Because the Tavistock have always made it absolutely clear that if the child doesn't agree, that parental consent is not enough. So I'm just wondering when any application would be made.
Well, okay.
Because a court, just following it through for a moment, a court can't ever order a doctor or a hospital to provide treatment. So we now have, if all three consent, you don't go to court. Tavistock have made it very clear they wouldn't contemplate treatment if the child objects. And if we have a situation where the child and the parents want it, but Tavistock doesn't think it's the right thing, the court isn't going to order Tavistock to provide the treatment. So I'm just wondering where that leaves the guidance.
Well, it leaves the guidance exercise for throwing its protective cloak around the child, to borrow the phrase from the authorities that have picked up in AB and CD. That was the thinking behind the court's guidance. It's nothing to do with the fact that the child could not consent. In fact, for an over 16-year-old, it was clearly accepted that, and the case law is X, the Mundy case that we've looked at, that once over 16, the presumption applies. But in that circumstance, re-W, the court can, in particular circumstances, see Nolan at page 94 of re-W, throw its cloak around the child in order to protect it. And that was the thinking behind that bit of the guidance, particularly about 1617, is that this is for the reasons I give 134, a concerning treatment, such that it's akin to sterilisation. This is how it was argued below. I mean, I'm sort of developing my ground 3 point. Essentially, below the argument was puberty blocking in its effects is akin to sterilisation because of the consequent cross-sex hormone. Sterilisation cases, as a matter of practice, do go before the court. Re-F.
Well, they go before the court even if they're therapeutic.
Yeah.
Do they go?
Well,
query. Do they
Query.
go if they're therapeutic?
Query the therapeutic, non-therapeutic. It's discussed in AB. There's the cases are reproduced, and Re-D stands on its own as the young child who. So I don't.
That's the
maybe
6-year-old untherapeutic.
But the thrust of the point is that, if I may, without going through those authorities, the thrust of the point is that in sterilisation cases, put to one side therapeutic, non-therapeutic, it may be appropriate to involve the court. I put no harm in that. Even if the parents and the child think it's a good idea. Re-D, everyone thought it was a good idea, apart from, I think, the education person who said, "Hang on, what's going on? We don't think this is appropriate." That was the context in which this guidance is being given, because it said, in circumstances where a treatment has these consequences, it's the sort of thing where the court has a duty to protect the child. Parents patriae, whatever phrase one uses, and it needs to be protected. And that is the heart of what's in the guidance, both for over 16s and under 16. And we therefore say that guidance of those cases should come to court, and the consequent amendment and pausing that NHS England have applied, and the creation of this panel, are a means, and through AB, are a means of rendering some part of that guidance unnecessary, so far as AB and CD reigns good law. But the guidance itself was, at the time it was made and the way it was given, was not at all improper. It was appropriate. May I, and I will do so briefly, summarise then in response to the ground. I should confess that I've probably covered most of these points in the course of argument anyway, but just really by way of a check through. Round 1, using is I've dealt with exhaustively, and our case is there's no departure or restriction of Gillick by paragraph 138. It is an application of Gillick. And in answer to my Lord the Master of the Rolls' point, well, isn't the guidance inconsistent with Gillick? I've said it's not inconsistent with Gillick, and it is just guidance, not law. Round 2, this really concerns the equation between the Mental Capacity Act and Gillick. We take the line of Munby that really the Mental Capacity Act doesn't shed too much light, in the way that the only relevance is the crossover between salient facts in, for example, Re-S, and that is squarely based on Gillick, not on anything in the mental capacity.
Well, I think that's one issue, but one issue on which there's almost common ground here, that the Mental Capacity Act is a diversion, and that certainly the ingredients of consent didn't suddenly change when the Mental Capacity Act came in.
So there wasn't a wrongful application of the law, we say, on mental capacity, because there was a correct application of Gillick as to the understanding, weighing information process. And I showed you a part of S where there was essentially agreement as to that by counsel in that case, but it reflects the Gillick law. There's a paragraph 53 of my skeleton. I observe that there's a second argument under this ground that the divisional court was in error in holding that a child or young adult contemplating PBS needs to understand information relevant, not every collateral decision, and that was really the same as the cross-sex hormone. It's tied up with that. I hope I've answered that, and I say that the court answers that. It assesses the defendant's evidence. It reaches a conclusion that it's proper to consider cross-sex hormones as following from PB, such that that's an salient fact that the child needs to be brought to the child's attention and to fully understand. The next point is to move, if I could move to ground 3, the suggestion that there was an error of law in concluding that 16, in respect of the guidance in respect of 16 to 18-year-olds, and I partially answered that, I think, already by referring to our point. It's not about, this is not about capacity or consent assessment or competence assessment, it's about the protective role of the court, the VW patriarch jurisdiction, and the circumstance in which that will take place. That REX confirms that the court can override the views of 16 or 70-year-olds and veto treatment in an appropriate case. And we've looked at the case all about that, and I've given you one of the references to Nolan. That override is, just for your note, if I may, rather than taking you to it, as I mentioned to the Lady Justice King, Lady Justice King, in our reply, the reference is Core Bundle 443 to 444, we drew the sterilisation comparison and mentioned REF, and we say that leads on to that discussion that one sees in AB, and the post, the question of the court is, where does that leave paragraph 147 of the guidance, as say post AB? We point to, we consider it to be appropriate condition to involve the court in any case where there may be doubt as whether it's the long-term best interest of the 16 or 17-year-old will be served by clinical intervention this year. And that, to some extent, has been taken by AB, but the point that remains is, if there's doubt, then an application to court would be appropriate. We see there's nothing wrong with that guidance. Ground 4 was experimental. I've largely covered that. The answer to this is really the judgment itself, paragraph 134. In response to arguments made in the appellant's skeleton, this isn't about looking at other cases where the term experimental has been used, but rather understanding how the court used that term, and is explained how they used that term in paragraph 134, and for the reasons they give, and based on the defendant's own evidence, leaving aside the background evidence, which they're entitled to take into account as well from the witnesses of the claimant, it was rightly described as experimental, as they do say in paragraph 134. Ground 5 is error of fact. That is to say, the correlation between puberty blockers and progression to cross-sex hormones. The divisional court's finding on that is at paragraph 136, and we say is unimpeachable. And we say so because the evidence before the court, which they cover at length, including the statistical evidence and so on, evidence from the defendant, this wasn't a resolution of conflicting opinion. Rather, it was an assessment and evaluation of the evidence presented by the defendant in respect to blockers, and their phrase, in our view, this does not reflect the reality, the end of 136. The evidence shows that the vast majority of children who take EVs move on to cross-sex hormones. Stages 1 and 2 are two stages of one chemical pathway, and once on that pathway, it's extremely rare for a child to get off it. It is one that not only is it open, it's what Anne de Vries describes how the person undergoing the treatment actually experienced the treatment. So that really can't be said to be an error over the course. And of course, if any of these errors would have to pass the tests of a court interfering with a finding of fact, even one by a court looking at written evidence we've set out in the skeleton, the test for that. These are entirely appropriate conclusions. Ditto, and I'm not going to repeat the content of the skeleton, ditto the experimental which I've mentioned. As to serious procedural irregularity, I dealt with that to some extent yesterday. I dealt with the expert evidence, how it came up, how it was dealt with, both at the hearing and then subsequently by the court. This was not used and made no substantial difference. It is not a valid ground of appeal, reasons given by the court itself. As to serious procedural irregularity, impermissible resolution of issues of clinical opinion, well, the court says itself that it did not impermissibly resolve issues of clinical opinion, and we submit it did not do so. It undertook an entirely appropriate judicial assessment of the evidence before it on a judicial review, probed that evidence, as we can see both from the transcript and from the judgment, where questions were plainly asked to the appellant as to produce data and explain to us how certain things happen, and then conclusions reached. In those circumstances, my case is, again, there's nothing in that ground. Human rights, not raised below. Short answer, no direct infringement of any human right, because the treatment applies to all children, regardless of their gender identity. So it's hard to see how the claim for direct interference with Article 8 rights occurs. But in any event, the mode of approach of the court was to require the involvement of the court. It's difficult to see how that could be not Article 8 compliant. In terms of, so far as it said that there's some kind of indirect discrimination, and I understand that point to be that it has a disproportionate effect on a subgroup of the overall class, who, for example, may identify as having other status, then it is justified by legitimate aim to protect children and is proportionate in all circumstances going to court. So it is justified on that basis. And an additional point we raise in our supplemental skeleton, in response to the suggestion that children and adults should be treated the same, Axon tells us, paragraph 152, that there's clearly a principled basis to treat children differently from adults without contravening any Article 8 rights. We've been pretty dismissive, really, of the suggestion that we're in Article 2 or Article 3 territory. We've given some cases, we haven't reproduced them all, but frankly, we're not in that territory, and I wasn't going to address the court in detail on those, because I don't think it's properly arguable that we are in that territory. In those cases where, for example, after all the cases where anything like the police have been involved with either detention cases or cases where the person has been in state custody or deportation or something like that, and it's just not at all comparable. That then, so I stand by the supplemental skeleton on those grounds, and if I may just finish by doing what I hope is a sort of final summation of where I am on the case. The court was confronted confronted with a practice which in key respects permitted or encouraged unlawfulness, in that such that there was permitted or sanctioned or encouraged unlawfulness, such that children were not able to give, or are not able to give, properly informed consent for treatment in the context of the case as it was argued, which focused on the child's consent, so pre-AB, and that the decision that the court reached, confronted with the evidence it had, was an entirely appropriate and just one of the evidence, and that the court had a duty, seized of the issue in the judicial review proceedings for which permission had been granted, to grapple with the issue raised before it, which identifies on more than one occasion, but for example at paragraph 9, the legal issue before us is, and did so, and is not to be faulted for doing so, and not to be faulted for, in the exercise of its discretion, granting a remedy of declaratory relief in respect of paragraph 138 of the judgment, nor in respect of its discretion to grant guidance, to promulgate guidance as summarised in paragraph 145. We say not to do that which the court did would have been a failure of its duty to protect the rights not just of children, of clinicians, and of parents, because this was an issue that needed to be grappled with by the court, and it did so, we say, in admirable fashion, and reached conclusions which are sound. Yes, I'm sorry, I finished early, but I'm not apologising.
Well, no, please don't apologise for that.
Yes, thank you.
Mr. Heim, thank you very much indeed.
My Lord,
Mr. McKendrick, yes.
Yes, good afternoon. I have 45 minutes, and I'm going to break down my submissions, my Lord, into 4 subsections. First, a brief introduction. Secondly, a brief analysis of the law in 2 areas, Gillick competence and the MCA, the Mental Capacity Act. And secondly, the role of the patient's autonomy in both competence and consent. Before turning to section 3, to look briefly at some of the evidence of paediatric endocrine practice. And then lastly, dealing very briefly with 1 or 2 of the appellant's grounds of appeal. Obviously, I'm not in a position to cover all of them, but my clients, both of them, support the appeal, as you will have seen in our written document. We are particularly concerned with the declaration made encapsulating information at paragraph 138, and much of what I will say will focus on why we say that declaration is wrong. We say if that declaration is wrong, then the guidance is also wrong and must fall away, because the guidance is, if you like, parasitic on the correctness of the declaration. And the 4 key points that we make really are, first of all, that the declaration improperly imports parts of the legal test for incapacity into the factual inquiry, which is Gillick competence, which is directed at clinicians, not the court. Secondly, the declaration confuses competence and the risk factors which are relevant to consent. Thirdly, the practical effects for this cohort of patients is that it collapses what would be at least 3 decisions, typically taken over the period of some 5 to 8 years, into 1 decision taken at an earlier age. And fourthly, the approach of identifying a relatively lengthy list of relevant information really isn't workable in clinical practice. And that undermines the clinical certainty clinicians require to treat their patients effectively. And it also undermines patients' autonomy in respect of consenting to medical procedures. Can I turn to one important issue which has emerged this morning in respect of the standard operating practice? I think it's very clear in the court's mind that my clients prescribe the puberty blockers following a referral from the Tavistock. They will make that decision as paediatric endocrinologists. Sometimes they continue to prescribe and administer from the hospitals. On other occasions, they pass over the administration to general practice, retaining a supervisory role. But the decision whether or not to prescribe is a decision for a paediatric endocrinologist at one of the two trusts. The document which Mr. Heim seeks to challenge in the standard operating procedure is a document which relates to the Tavistock, and that is no more, I'll take the court to it, than a consent procedure in respect of referring patients to the trusts. It does not purport, we say, to be the document that determines whether an endocrinologist assesses Gillick competence and obtains consent. It may well be, I don't need to take my lords, my lady back to it, but it's clear from 53 that it is concerned with consent for referral to endocrinology, and it says at paragraph 1.11, consent for referral to the endocrine liaison clinic for consideration of hormone blockers. Once the patients come to the two trusts, they are subjected to a series of physiological tests, which involve bone density scans, liver and blood tests, checks in respect of where they are as against Tanner stage 2, and continued psychological and psychiatric evaluation because a clinician from the Tavistock joins them. Some 6 to 12 months typically later, a decision will be made as to whether they're Gillick competent and whether their consent is obtained to prescribe. So the document that seems to be under challenge is not the document that deals with the question of prescription. And there has a confusion, has undoubtedly crept into this claim, because the grounds of claim challenge the prescription of puberty blockers by the defendant, Tavistock. Tavistock don't prescribe puberty blockers, as my lord, the Lord Chief Justice remarked only some 30 minutes ago. And for your reference, 455 of the core bundle is the amended grounds of claim. That, of course, was pointed out to the claimants by the Tavistock's legal team, and in effect, they altered their claim, and their claim as set out in the first paragraph of their skeleton argument. This is 546 of the core bundle. It might be worth just turning this up. Core bundle, page 546. I'm not taking technical pleading points, but it is an important point about which policy or which practice was being challenged. Paragraph 1 of the skeleton says, this is a challenge to the defendant trust's current practice through its gender identity development service of referring children under the age of 18 who experience gender dysphoria to the endocrinology services at the first and second interveners for the prescription of gonadotropin-releasing hormone agonists, hormone blockers.
Yeah. But the claim wasn't amended, was it, to do that?
I don't believe it was, my lord, no. And there's further confusion, because if one goes forward in this document, paragraph 11, page 550, the declaratory relief that is sought is against the defendant's current practice of prescribing stage 1 hormones. So, when the court came to deal with it, in the judgment, paragraph 2 of the judgment of the court below, page 75, focuses the issue on, this is the claim for judicial review of the practice of the defendant, the Tavistock and Portman NHS Foundation Trust, through JIDS and the first and second interveners trust of prescribing puberty-suppressing drugs to persons under the age of 18. And paragraph 138...
So which paragraph is that?
That's paragraph 2, my lord, page 75. And it's abundantly clear, paragraph 138 is focused on the issue of prescription. So in answer to my lord, the Lord Chief Justice concern regarding what is the policy, that the circular, to use the earlier language from Gillick, it cannot be the standard operating procedure that Mr. Hymes identifies. I will take, my lords and my lady, very probably after lunch, to the documentation that the two prescribing trusts rely on. The important thing to recognise in respect of those documents is the court's conclusion at paragraph 150, at the bottom of page 109, where the court records that the alternative ground is that the information provided by the defendant and the trust is inadequate to form the basis of informed consent. And the court goes on to say that they accept the defendant and the trust in their written information have tried to explain the consequences in an age-appropriate manner. So the court found that the documentation was appropriate and suitable and lawful.
Including that of moving on to CSA.
My lord, yes. So what we're left with is not a practice. We're simply left with the fact that the trust, as a matter of fact, on some occasions concludes that the patients in its care are either Gillick competent or capacitous and consent. That's a question of fact for clinicians. The first claimant in the claim for judicial review was treated 8 years ago at the age of 16, and the second claimant's child, certainly at the stage when the claim was issued, hadn't found their way to the endocrine clinics. If there was a private law claim for negligence or assault, that a patient was incompetent or incapacitous and therefore was incapable of consenting, then there would have been specific concrete factual evidence from the clinician who took that decision, medical records, cross-examination, and we might get more closely to the heart of the issues. But one of the great difficulties with this judicial review from my two clients, not served with a letter before claim, not joined as the defendants, not even referenced as an interested party, having to make their own application to intervene and bear their costs throughout of both sets of proceedings, is that they have a judgment of paragraph 138, which sets out the issue that Gillick says clinicians should themselves decide without the court hearing any oral evidence from those highly experienced paediatric endocrinologists. We say it is all deeply, well, certainly confusing, but it creates much further confusion for the practice of not just paediatric endocrinologists, but all clinicians. That is a rather lengthy introduction. Section 2, I'm keeping an eye on the clock, my lord. I'm happy to break now if that's...
No. I think we'll crack on if you can use the next 5 minutes
My lord,
usefully.
of course. So turning then to the question of the law, without going back to Gillick, I just emphasise points which Miss Morris took, my lord and my lady, to yesterday. Lord Fraser and Lord Scarman at 172C on page 123 and 189A on 140 clearly emphasised that Gillick is a question of fact. It's a factual inquiry. And as my lord, the Master of the Rolls, referenced again just 20 or 30 minutes ago, it is a question of fact directed at the clinicians. And there's no need to turn it up, but if one looks in the supplementary bundle at page 262, one can see the statement from the Academy of Medical Royal Colleges, which makes clear that the Gillick test works and is a Gillick test of fact that clinicians should apply, and changes to that would be detrimental to the safety and well-being of children. The importance of that factual and child-specific inquiry is emphasised by Sir James Mumby, whilst president of the Family Division, in the case called Reedy, a Child. I don't ask, because of limitations of time, the court to turn it up, but it begins at page 561 of the supplementary bundle of authorities, and the passages I rely on are 83 to 84, which are at pages 587 to 588. They are referenced in my skeleton argument. And essentially, Sir James Mumby emphasises the factual inquiry, but the child-specific nature of that inquiry, which we say is very important. The Mental Capacity Act has a quite different approach. Sections 1, 2, and 3 of the Mental Capacity Act, and it might be worth briefly turning them up. They're in the first bundle of authorities at page 58. In fact, it begins on page 57, and I will begin with section 1. The principles are set out at sections 1 to 6, but I particularly rely on section 1.2, that a person must be assumed to have capacity unless it's established that he lacks capacity, and a person is not to be treated as unable to make a decision unless all practical steps to help him do so have been taken without success. And section 1.4, a person is not to be treated as unable to make a decision merely because he makes an unwise decision. Those are cardinal features of the court's approach to sections 2 and 3, which determine the mixed question of fact and law, which is a determination of capacity or incapacity. But those three initial sections, sections 1, 2, 1, 3, and 1, 4, don't apply to Gillick competence. There is no assumption that a child is Gillick competent in law. It's a factual inquiry to be taken at the time. There is not the same statutory requirement that all practical steps must be used so that the decision can be taken. The normal developmental trajectory of children continues to apply. And section 1.4 regarding unwise decisions, in some ways that may be a large part of Gillick competence, is that whilst a child may have the understanding and the intelligence, their lack of life experiences or maturity lead them to make unwise decisions, but they would not be Gillick competent. So there are some very significant differences. And what sections 2 and 3 do are forensically set out the requirement for a judge, in many cases, to identify the relevant information so that that relevant information can be tested against the symptoms of a diagnosed impairment or disorder. Again, it's a very different process from Gillick competence to protect those who may be disordered or have an impairment. This is about protecting them and promoting their autonomy, and has a very different purpose or role. So I will, after lunch, return to this theme, but the identification of relevant information at paragraph 138, while consistent with the MCA, is simply not consistent with a clinician's factual inquiry of an individual patient. Typically, and my Lady Justice King will recall from her years sitting as a judge of the Court of Protection, the identification of relevant information would normally come about after a psychiatrist or psychologist has given oral evidence and been questioned, and then the judge takes the decision as to what is the relevant information for this patient and this decision. But we didn't have that opportunity in these proceedings as they were judicial review. My Lord, 2 minutes past 1, I think. So shall I pause there? And
If that's a good moment for you,
Lord, yes, thank you.
we'll do that. So thank you very much. We'll rise now and see you all again at 2 o'clock.
All right.